Hello everyone, and welcome to Taylor Wessing's latest webinar and part of our ongoing data protection series where we bring you our expertise and our views on topical data protection issues. My name's Sally Annero and I'm a senior member of the London Data Protection Practice. Those of you who join us quite regularly with these webinars will know that we have tracked a wide range of webinar topics over the years, including core requirements and practical applications of the GDPR, sessions where we've looked at data protection considerations for particular areas such as more recently children, ad tech and cross-border data flows, and then Brexit of course, and as well as cybersecurity and direct marketing. And past recordings of those webinars can still be accessed from our global Data Hub microsite if you want to revisit any of that content. Today is the first of two webinars where we're going to be looking at the application of the GDPR to life sciences. Today's session starts as a primer, so we're going to be taking a high-level look at core concepts of the GDPR relevant to that sector, and we'll also look at, say, the requirements of the GDPR and how they intersect with private life sciences businesses and their other requirements. At the end of our webinar today, we'll have our usual short selection of polling questions where you can have an opportunity to give your feedback on a few topical questions and get a view in the aggregate of the collective response of the listeners today on those questions. Putting data protection to one side for a moment, those working within life sciences, like businesses in pharmaceuticals, biomedical and biotechnology fields, are going to be aware that this is one of the most heavily regulated sectors. It already operates within a long-standing and separate framework of regulatory, professional and ethical standards, and which includes, for example, clinical trials regulation and other European and national pharmacovigilance legislation. As part of that mix, data protection law will also have a particular relevance where information about individuals, including sensitive health information, plays a key role in activities like research, like the development of scientific knowledge, the exchange of ideas, and developing, delivering and monitoring treatments and technologies. It's in part the nature of these separate ethical, regulatory and professional frameworks that create specific challenges for the life sciences sector in terms of understanding their interrelationship with the GDPR and what it has to say about the processing of personal information of individuals. As I've mentioned already, this is part one of two separate talks, and where part two will then drill down to look at particular issues and case studies for the sector, including in the context of clinical trials. I'm joined today by my colleague, Debbie Hayward, who's a senior professional support lawyer in Taylor Wessing's Commercial Technology and Data Group in London. And without further ado, and to get part one underway, I will hand over to Debbie to get us started.
Thanks, Sally. I'm a little bit croaky today, so I hope you'll be able to bear with me. So I'm going to start by looking at territorial scope. It's important to understand that the territorial scope of the GDPR because life sciences businesses often operate across multiple jurisdictions, particularly, for example, when it comes to clinical trials. So the GDPR doesn't just apply to EU organisations. It also covers non-EU organisations offering goods or services to data subjects in the EU or monitoring their behaviour to the extent that the behaviour takes place in the EU. This means that multinationals can't afford to ignore the GDPR, even if their head offices are outside the EU. But it also means they may be able to take advantage of one of the great benefits of the GDPR. Multinationals with establishments in more than one EU member state or processing the personal data of individuals from different member states can appoint a lead EU regulator in respect of that processing and take advantage of the one-stop shop regulatory mechanism rather than having to deal with a number of regulators across the EU, provided that they're able to identify a main establishment with responsibility for the decision-making relating to the processing of the personal data. And this is a really positive change, and so far the system seems to be working pretty well where it applies. Enforcing the GDPR against a business without an EU presence is a challenge for regulators, and the GDPR attempts to deal with this by introducing a requirement for non-EU organisations caught by the GDPR to appoint a representative who basically acts as a conduit between the non-EU controller or processor and the relevant EU regulators and data subjects. Now, UK organisations haven't really had to think too hard about representatives to date. Brexit, however, is likely to change this. UK businesses which have no other establishment in the EU but which are within the GDPR's territorial scope will need to appoint a representative at the end of the transition period, so that's at the end of this year, unless and until alternative arrangements are agreed. Similarly, the UK government intends that after the end of the transition period, the UK version of the GDPR is going to require that a controller or processor located outside the UK but caught by the UK GDPR will be required to appoint a UK representative. So moving on now to what is personal data. I mean, this is basic stuff, but it is really important. It's a wide definition. It covers any information relating to an identified or identifiable natural person. That's anyone who can be identified directly or indirectly, and crucially, it includes pseudonymized data. Pseudonymized data is data which can only be attributed to an individual when combined with additional information, where that information is kept separately and is subject to technical and organizational measures which protect the individual from being re-identified. For example, a unique ID for a trial participant. This is an important distinction for life sciences businesses. You might be able to do more with your personal data by pseudonymizing it, not least comply with security requirements, but it remains personal data. It's only by completely anonymizing the data in such a way that it can't be re-identified from other information that the data falls outside the scope of the GDPR. Special or sensitive personal data is a subset of personal data, and it accounts for the majority of personal data processed in a life sciences context. Kind of personal data attracts additional protections, which Sally is going to discuss later. Special categories of data likely to be processed include genetic data, biometric data for the purpose of uniquely identifying a natural person, data concerning health, religion, ethnic background, or data concerning a natural person's sex life or sexual orientation. So there may be large amounts of personal data floating around. A lot of it might be sensitive, and it will be passing between different actors in a clinical trial or research study. Who's responsible for it? Well, the primary responsibilities for the processing lie with the data controller, and that's basically the decision maker or makers who decide on the purposes and means of the processing. In the context of a research study, for example, the sponsor will most likely be the one who decides what data is collected for the study and will be acting as a controller in relation to the research data. GDPR also introduces direct obligations on data processors, and these are organisations which process personal data on behalf of the controller. And these obligations are new to GDPR, are new to data protection regulation. Clinical or contract research organisations are often data processors, for example. Obligations on processors include keeping data processing records, security obligations, and reporting requirements. Data controllers have to have written agreements with their data processors which need to cover specific elements. In some cases, there may be more than one data controller with regard to a data set, and they may become joint controllers, so they jointly determine the purpose and means of the processing. This can be, but is not always the case, with the sponsor of a clinical trial and the trial centre. The sponsor may draw up the protocol, produce guidelines and verify compliance, while the trial centre will conduct the trial and deal with providing patients with information and getting their consent. If both the sponsor and the trial centre will be making decisions about the data processing relating to the trial, they will be joint controllers. It's also possible for two parties to be controllers in common. If this is the case, having a clear protocol for managing the transfer of personal data between them is crucial, and giving clear and proper information to data subjects about the data processing activities of each party will be important but often difficult. It should always be clear both to the parties and to the data subjects what each controller of data is doing with it and for what purpose. And this is really quite a tricky area for life sciences businesses, and the roles don't always fit neatly into the GDPR categories. And it's also worth mentioning that different member states take different approaches, so this is an area which needs to be thought through really carefully at the outset of a processing operation. Moving on now to the data protection principles. These are at the heart of the GDPR, and they should underpin and inform everything you do with personal data. So personal data has to be processed fairly and lawfully, and part of that requirement is providing individuals with set information as to what is happening to their data throughout the processing journey, including when it's transferred to other controllers or processors. Data has to be collected for specified, explicit and legitimate purposes and must not be processed for further purposes incompatible with that original purpose. Potentially useful exemption for life sciences companies is provided here under Article 89(1) of the GDPR, which says that further processing for scientific or statistical purposes will not be considered as incompatible with the original purpose where it's used to help ensure appropriate safeguards are in place to protect individuals. These include organisational and technical measures to help ensure data minimisation, and again that might include pseudonymisation. Data has to be limited to what is necessary for the purpose for which it's processed and must be accurate and up to date. It must also be kept for no longer than is necessary and be kept secure against unlawful processing, accidental loss, destruction or damage. Crucially, it's not enough to comply with these principles. You have to be able to demonstrate compliance in accordance with the accountability principle. This is a driver for many of the processes and policies which data controllers and data processors need to develop and follow in order to be GDPR compliant. In particular, a record of processing activities must be kept by the data controller or their appointed representative. I'm going to hand back to Sally now, who's going to look at lawful basis.
Thanks, Debbie. To comply with the principle that personal data be processed fairly and lawfully, which is at the heart of the GDPR, is a need for visibility around the legal grounds relied upon for specific processing activities. This means that each purpose for processing must be carried out under one of the specified lawful bases set out in Article 6(1) of the GDPR, and the controller has to identify the basis appropriate to their particular processing. It's not possible to just select a handful of potentially likely-looking lawful bases and hope one hits the mark. Only one lawful basis must be identified as applying to one purpose for processing. That said, of course, where personal data are being processed for different purposes, then different lawful bases may apply to each of those different processing activities. There are a number of lawful bases which may apply to personal data processing by life sciences organisations, and the controllers for the processing need to consider carefully which one applies. From a regulatory standpoint, informed consent plays an important function, particularly as a requirement for participating in clinical trials, for example. However, care needs to be taken to avoid confusing informed consent in that context with the separate standard of consent required for processing personal data under the GDPR. So it needs to be clear to data subjects what their consent is going to be covering in each case. Under the GDPR, consent must be freely given, specific, informed, and an unambiguous indication of the data subject's wishes. In particular, it can't be freely given if there's an imbalance of power in the relationship between the subject and the controller. And crucially, the subject must be able to withdraw their consent at any time without suffering detriment. In the case of sensitive personal data, which I'm going to mention again later, consent must also be explicit. And again, in a life sciences context, that can be difficult to achieve and may not be the most relevant lawful basis on which to rely. For example, a data subject who's exercised their right to withdraw consent to processing as part of a clinical trial would, in reality, have a major impact on the performance of that study. The ICO's guidance on consent states that in the healthcare context, consent is often not the appropriate lawful basis under the GDPR. Instead, healthcare providers should identify another lawful basis, such as vital interests, public task, or legitimate interests. The stricter rules on special category data, Article 9(2), specifically legitimises processing for health or social care purposes. In addition, the NHS Health Research Authority also makes clear that for the purposes of the GDPR, the legal basis for health and social care research should not be consent, and that for commercial companies, the processing of personal data for research should instead be carried out within the grounds of legitimate interests. Under the GDPR, legitimate interest is more than just a general sort of sweep-up justification for processing personal data. Organisations must be able to demonstrate that they, A, have a legitimate interest, but B, the test is necessary to achieve the purpose, and C, is not overridden by the rights and freedoms of the subjects which require protection. As I mentioned, the Health Research Authority guidance points to legitimate interest being the correct lawful ground to rely upon by commercial companies and charitable research organisations when processing personal data for research purposes. As Debbie mentioned, accountability is a key part of compliance. So I'm losing my voice as well. Accountability is a key point of compliance under the GDPR, and in relation to identifying lawful grounds for processing and where legitimate interest is relevant, there needs to be an assessment against those three legitimate interest tests I mentioned, the A, B and C, and that needs to be carried out and a record kept in order to demonstrate that from the accountability standpoint a proper assessment of the legitimate interest being relied upon has been made. Although I've focused here on two lawful grounds for processing that are particularly relevant and attract the most attention, there are, of course, others. For example, it may be that for specific processing of personal data, that processing is necessary to perform a contract that is entered into between you and another party. Or it may be that the processing is necessary for compliance with a legal obligation, and that might be because, for example, there's a pharmacovigilance or product safety obligation on the company. Or it may be that the processing is necessary on the grounds of public interest or exercise of official authority, which would be more relevant to public bodies, or where necessary to protect the vital interests of the subject or another person. So where, for example, there's a critical health decision that needs to be made about someone and they're not capable of providing their own consent in relation to that processing. So moving on, life sciences businesses may also often process large amounts of special category or sensitive personal data, as defined by Debbie earlier. Not only is a general lawful basis under Article 6 needed to process special data, but there's a blanket prohibition on processing this kind of data unless one of the conditions in Article 9.2 of the GDPR also applies. A number of these conditions may apply to special category data processed in the context of life sciences. We've already mentioned consent and the particular considerations relevant to relying on that basis. If consent is a condition that is relevant in a particular context, then in the context of sensitive data, that consent would need to be explicit. As I mentioned, that actually makes it more of a challenge to obtain a valid consent. Other grounds that can be relevant here are also vital interests again, where the processing is necessary to protect the subject's vital interest and they're physically or legally capable of giving consent. Public interest, so where it's necessary for reasons of substantial public interest on the basis of union or member state law, which are proportionate to the aim pursued and subject to safeguards to protect individuals. Where relevant to medical or healthcare, so it's necessary for the purposes of preventative or occupational medicine, medical diagnosis, provision of health or social care or treatment, or the management of health or social care systems, for example. Or where processing is necessary for reasons of public health in an area of where perhaps there's a need to protect against a serious cross-border threat to health or ensuring high standards of quality and safety of healthcare or medical products or medical devices. There's also a requirement here to provide suitable safeguards to the rights and freedoms of the subjects. And then there's scientific research, where processing is necessary for research or statistical purposes, provided it's proportionate to the aim pursued, respects the essence of the right to data protection, and specific measures are in place to protect the rights of individuals. The Data Protection Act 2018 suggests that this only applies where there is also a public interest element, and that the Article 89 requirements, which Debbie will be talking about later, are met. From a health research authority perspective, where we're talking about processing of personal data for research purposes, then scientific research is most likely to be the relevant lawful ground for the processing of any special category data.
Right, I'm going to move on to data protection by design and default. This is a phrase you might hear quite a lot. It's covered under Article 25 of the GDPR. And basically that says that data protection by design and default has to be hardwired into compliance. So what exactly does that mean? Well, essentially it means that data protection has to be considered at the earliest stages of a project and built in from the start. The GDPR does allow for a balancing exercise, the state-of-the-art and costs of implementation against the rights of the individuals associated with the processing. Having made this assessment, the data controller then needs to implement appropriate technical and organisational measures. Here again we've got this vague term which appears repeatedly in the GDPR, but in this case we do have some examples which are given. So again, pseudonymisation and data minimisation are both seen as effective in this context, and they're going to be important safeguards in the context of health and social care research. Control is also required to put appropriate technical and organisational measures in place to ensure that by default only data necessary for each specific processing operation is processed in relation to it. And this covers the extent of the processing, the retention period and the accessibility of the data. This aspect of compliance may be particularly challenging for life sciences companies, where the need to quickly capture and communicate data about adverse incidents is as crucial as the need to prioritise privacy. And you may have to make an extra effort to meet both goals without compromising on either. Certification mechanisms may be introduced in future to help organisations demonstrate compliance with data protection by design and default, but at the moment it remains something of an inexact science, and you really do need to make judgment calls. And that brings us quite neatly onto the subject of data protection impact assessments, or DPIAs. Now these aren't new, you should hopefully be familiar with them. But data protection regulators have been recommending them for years, but under the GDPR they are mandatory in certain situations. To a degree there's also an element of self-assessment here. Article 35 says that DPIAs have to be carried out when a type of processing, particularly one using new technologies, is likely to result in a high risk to the rights and freedoms of individuals. A DPIA is specifically required where automated processing, including profiling on which decisions are based which have legal or similarly significant effect on the individual is involved, where there's processing on a large scale of special categories or sensitive personal data, and where there's systematic monitoring of a publicly accessible area on a large scale. So when you're deciding whether processing is likely to result in high risk, you also need to consider European data protection guidelines that define different types of likely high risk processing operations. For example, one of them includes storage for archiving purposes of pseudonymized sensitive data concerning vulnerable data subjects of research or clinical trials. So that's quite a specific category, but it may well be relevant. And each member state regulator also has to produce its own list of the kinds of processing operations which trigger mandatory DPIAs. And this means that there's a fragmented approach across the EU. You've got different requirements in different member states. The UK's ICO's list includes processing operations relating to innovative technology, including AI, large-scale profiling, including application of AI to existing process, biometric data under certain circumstances, genetic data including for medical diagnosis, DNA testing and medical research under certain circumstances, and where there's a risk of physical harm, so where a data breach might jeopardise the physical health or safety of individuals, and that covers social care records, for example. In compliance with the accountability principle, the decision about whether or not to carry out a DPIA also needs to be documented. If you have a data protection officer, they should be involved in the preliminary assessment and in any subsequent DPIA. The purpose of the DPIA is to assess the risks to individuals associated with planned processing operations. In other words, you have to do this before the processing begins. There are set elements to the assessment and what it needs to cover, and this includes envisaged steps to mitigate risk and demonstrate compliance. If you get to the end of the DPIA process, and you conclude that there is a high risk which you can't mitigate, the ICO or relevant data protection regulator must be consulted, and the planned processing can't take place until they have given the all clear. Now, this process should take about 8 weeks, but it can be extended for a further 6 if the planned processing operation is particularly complex, so this process really can't be rushed. Even if you're not required to carry out a DPIA, there are many areas where the ICO suggests it may be helpful to carry one out. And given that personal data used in life sciences projects can often be biometric, genetic, or involve new technologies, the likelihood is that a DPIA will be required and should at the very least be considered. Clinical trials often involve the transfers of large amounts of personal data across borders, including to third countries, that's countries outside the EEA, as you might have a network of laboratories or healthcare providers and potentially the sponsor of the trial who are all located in different jurisdictions. Under the GDPR, personal data can't be transferred outside the EEA unless there are protections in place to guarantee individuals equivalent rights and protections to those they enjoy in the EU. Those countries which are considered to have a data protection regime which provides an adequate level of protection equivalent to that in the EU can benefit from a Commission adequacy decision, and that will allow the free flow of personal data from the EU. Currently, 12 jurisdictions, including the Channel Islands, have full adequacy decisions, and Korea is being assessed. In addition, the US has a partial and somewhat controversial adequacy decision in relation to transfers under the EU-US Privacy Shield, but it's worth noting that this doesn't cover key-coded research data. In the absence of an adequacy decision, a number of other data transfer mechanisms can be used, principally the EC standard contractual clauses or binding corporate rules which relate to intra-group transfers. And there are some other limited options which may be available. In the event of a no-deal Brexit at the end of transition, so effectively if we get to the end of transition without some sort of post-Brexit agreement, the UK is going to become a third country for EEA data transfer purposes. Now, the UK is already committed to preserving the free flow of data to the EEA and to countries with existing EU adequacy decisions, and it's also negotiated agreements with all the countries who currently benefit from EU adequacy decisions. So the data flows to the UK from them will be uninterrupted by Brexit. But this does still leave a possible problem in relation to data flows from the EEA to the UK. And organisations which are particularly reliant on receiving this sort of personal data may need to put mechanisms in place to cover it off. So probably standard contractual clauses, but maybe binding corporate rules to avoid interruption. But you should remember that SCCs are in themselves currently subject to challenge. So again, this is something that you probably have to think about quite carefully. In addition to GDPR considerations, you may also need to consider other rules in the context of cross-border clinical trials, which might be local or regulatory obligations relevant to the processing or third-party hosting of health data, for example, the French Public Health Code. Sally, I'm going to hand back to you now to cover security.
Thanks. In practice, one of the central obligations under data protection law on both controllers and processors is to keep personal data secure, and the failure to secure data accounts for a significant proportion of the ICO, the Information Commissioner's enforcement activity in the UK. The appropriate level of security has to be determined taking into account factors such as the state of art, so the availability of technology, the cost to apply it, and the purposes of the processing, as well as the risks to the individual, particularly in the event of unauthorised or accidental destruction, loss, alteration, disclosure of, or access to data. The GDPR also places a separate emphasis on safeguards being necessary when processing data for research purposes that Debbie will also mention shortly. In the event of a data breach, controllers must also notify the relevant supervisory authority, in the case of the UK, the Information Commissioner, without undue delay and not later than 72 hours where feasible after becoming aware of the breach, unless the breach is unlikely to result in a high risk to the rights or freedoms of individuals. So, for example, if it was a file of encrypted, key-coded data, for example, where the data intercepted would make no sense to an unauthorised recipient. In addition, where there is a risk to subjects which cannot be mitigated, then the affected data subjects also need to be informed without undue delay, unless that would create a disproportionate burden, in which case it may be that that obligation would have to be achieved by some form of group or public notification. The GDPR also includes a requirement under certain circumstances to appoint a data protection officer or a DPO. The DPO is responsible for overseeing personal data processing activities, for monitoring the compliance by the organisation with the GDPR, and also acting as the contact point for inquiries from, for example, data protection authorities such as the Information Commissioner. A data protection officer or DPO must be appointed in cases where it's a public authority or a body, or the controller's core activities consist of processing operations that involve regularly or systematically monitoring subjects on a large scale, which might be relevant in the context of a research study. Or its core activities consist of processing on a large scale of sensitive data of the data subjects or personal data relating to criminal convictions. So again, it's likely, given the frequent use of sensitive data in life sciences, that this will mean that there are controllers and processors within the sector who are likely to be required to appoint a data protection officer, and even if they aren't, they may wish to or are able to appoint one voluntarily. Where they do appoint a DPO voluntarily, then all the obligations that apply in the GDPR to a data protection officer in terms of their role in the remit would apply to that voluntarily appointed DPO as well. In addition, the GDPR provides rights to individuals, so they have enhanced rights in relation to their data. Member states are able to derogate from some of these rights under the Article 89 that Debbie will mention, relevant to processing for research purposes. And this means that research participants may be unable to rely on some or part of these rights to seek to access, correct or erase data where the derogations apply, but not where data are being processed for other purposes unconnected to scientific research or statistical purposes. First of all, we have the right to information. This isn't technically a formal right under the GDPR, but it is it works in a similar way to one, in that data controllers are obliged to provide data subjects with a range of mandatory information at the time that data is obtained from them, in order to ensure that that processing is transparent. So in other words, individuals have a right to receive information. The type of information that must be supplied will differ depending on whether or not the data is obtained directly from the subject or indirectly. This means that information may need to be provided about personal data processing relevant to both a study site and to the study sponsor. Separate from GDPR requirements, there may also be ethical regulatory obligations to provide general clarity to study participants about the use of their data, even where that data ceases to be personal data. In each case, such information does not necessarily have to be provided as part of a study participant information sheet. It could also be documented and provided to participants separately, for example, by way of a privacy policy or a notice. Careful thought needed to ensure that the information is sufficiently detailed to guarantee the validity of any informed consent, where consent can be relied upon to process data, whilst also remaining broad enough to allow for necessary flexibility within trial processes, for example. Another right that data subjects have is the right to request access to their personal data, together with being given certain associated information about the processing of that data that relates to them. They also have the right to obtain a copy of this information. Now, this can be particularly challenging where the processing activities are confidential, and providing copies of data could risk the integrity of trade secrets or patent prosecution processes. Hence the reason why there are certain exceptions from the subject access right. There is also then the right to have inaccurate data corrected or incomplete data completed, and to restrict processing under certain specified circumstances, mostly where the processing is subject to some form of dispute. Individuals can also ask for their personal data to be erased or deleted under certain circumstances. This includes where processing is based on consent, and is another reason why consent may sometimes be more of a challenge to adopt as the lawful basis of processing in relation to certain types of processing, such as clinical trials or pharmacovigilance. There are, however, exemptions to the right to erasure for reasons of public interest in the area of public health and for scientific or statistical purposes in accordance with Article 89, research purpose. And that's where exercising the right would render impossible or seriously impair the objectives of that processing. Where processing is based on consent or carried out for performance of a contract, or where it's automated, the individual has a right to receive the data and to transfer it to another controller. The data must be provided in a structured, commonly used and machine-readable format. This is called their right to data portability. Again, there is an exemption here under this right for tasks that are carried out in the public interest and where the exercise of this right can adversely affect the rights and freedoms of others. Data subjects also have a right not to be subject to a decision based solely on automated processing, including profiling, and where that has a legal or similarly significant effects on the subject. Where sensitive data is being used for profiling, it's only permitted with the explicit consent of the individual for profiling purposes, or where the profiling is necessary for reasons of substantial public interest and where safeguards are applied. Where machine learning is used in health products, this right is likely to be engaged. So it's also a potential issue in randomised trials where specific consent might be difficult and might alert the individual to the fact that they were part of a trial. The right to object is also relevant here. Data subjects have the right to object to processing where it's based on legitimate interest or where it's related to a task that's carried out in the public interest or in the exercise of official authority. If a data subject exercises their right to object, the controller can only continue processing if they can demonstrate that they have compelling and legitimate grounds which override the right and the freedom of the subject in order to make that request. Another example where controller may be able to push back on that request is if it was related to legal claims. All requests that are submitted by individuals exercising their rights have to be responded to without undue delay, even if the effect of the response is a negative, and in any event within 1 month of receipt, unless it's reasonable in exceptional circumstances to extend that deadline by up to a further 2 months, taking into account the complexity and the number of the requests that are received. Again, for accountability reasons, it's important to keep logs of requests received and how they were handled in order that an organisation can demonstrate to the regulator, the Information Commissioner in the UK, how they complied in practice with those rights requests that they received and to demonstrate that they were properly handled.
Right, I'm going to talk about Article 89, which Sally's mentioned a few times. It's quite complicated, so I'm going to try not to go into too much detail. Article 89 of the GDPR covers safeguards and derogations relating to processing for archiving purposes in the public interest, scientific research purposes or statistical purposes, and also historical research purposes, but that's obviously less relevant here. Life sciences businesses may find themselves subject to these safeguards, but they can also benefit from exemptions. Under Article 89, all processing of personal data for scientific research or statistical purposes must be subject to appropriate safeguards, key to which are data minimisation, including by pseudonymisation. There we go again. Where these purposes can be fulfilled by further processing which does not identify individuals, for example, anonymisation, then those processes should be applied. Article 89 is also the main source of exemptions and derogations from GDPR compliance for the life sciences data. Member States or the EU itself may provide for derogations from a number of the data subject rights in relation to data processed for scientific research or statistical purposes. And these are, Sally sort of mentioned some of them before, the right of access, the right to rectification, the right to restriction, and the right to object to processing. Where data is processed for archiving purposes in the public interest, derogations may also be made from the right to notification and erasure and the right to data portability. Now, the position varies across member states depending on which derogations have been implemented or provided for under national law. In the UK, it's the Data Protection Act 2018, and that covers the Article 89 derogations in Schedule 1, Part 6. To the extent that exercising their rights would prevent or impair scientific research or statistical purposes, data controllers do not have to give effect to certain rights, subject to various provisos. And this all starts to get quite complex, so I'm not going to go into the detail of what the exceptions are. But you should definitely take advice before deciding whether you can rely on an exemption, particularly because regulators are likely to interpret them fairly narrowly. So, Sally, back to you.
So, it's fair to say that there's a far greater awareness of the GDPR, of individuals' rights, and how to complain. And that, combined with the breach reporting obligations that we mentioned earlier, has resulted in far higher levels of regulatory activity by the Information Commissioner. Now, the focus of any talk on GDPR inevitably then ends up looking at the headline monetary penalties of 2 or 4% of global turnover for failure to comply with the GDPR. However, it's safe to say that only the most serious of breaches are likely to attract that level of penalty. The position in reality is far more nuanced. The regulator has a range of powers available to it, ranging from issuing warning notices and letters about processing activity to an organisation. It can also formally demand information in order to assess compliance, and it can issue formal assessment notices, which are much more of a formal way of indicating that it requires certain information in order to conduct a formal investigation. Failure to provide a response to a formally issued information or assessment notice could give rise to contempt of court for failure to comply. The regulator also has formal audit powers to assess processing activities, and then it can issue notices to specific notices that might, for example, seek to prevent certain processing activities or to cease processing, or even to delete processing. So where it requires a particular action to be taken, it might choose to take an enforcement notice route in order to achieve that outcome. And ultimately, the well-known and much talked about monetary penalty notices can also be fine issued, but again, the level of penalty that is issued will very much depend upon the circumstances of the breach, the nature of the organisation, its readiness to cooperate, the steps that it had already taken to put in place policies, procedures to seek to try and remediate the issue, and how it had cooperated. So there are a whole host of variables relevant to a decision taken by the Information Commissioner as to whether to issue a monetary penalty when it reaches that point, and indeed what level of penalty to apply. So from this, I think it's clear that organisations applying clear and strong practices to evidence their approach to compliance will go some considerable way to mitigate the type of regulatory response that they may receive in the event that they get to that level of discussion with the Information Commissioner. So we've now reached that point where you have the opportunity to give your feedback on a few topical questions, and that we can then share in the aggregate that response back. The first question we have is to ask whether you have reassessed your lawful grounds for processing personal data under the GDPR since the GDPR has come into force. So yes, you have revisited your lawful grounds for processing, so for example, consent, legitimate interest, whether that's an ongoing process or whether you have yet to start that exercise. The second question is, has your business designated a data protection officer? So again, yes, you have a DPO in place, you're thinking about moving to designating a data protection officer, or you've not yet taken that step. And thirdly, has your business implemented a data protection accountability management framework to be able to demonstrate your compliance? Again, yes, in progress, or yet to start. While we're waiting for the results of your answers, I'll just explain, for those of you who are unfamiliar with Taylor Wessing, that we are a leading international law firm. We act for a range of clients in local and international markets, and we provide a full-service law firm offering from an international footprint that spans Northern, Central and Eastern Europe, Middle East, Asia, and our US representative offices. Our data protection practice is equally international in scope, so we're a global 22 partner-driven international team. We're complemented by a broader international network of data privacy specialists who advise on all areas of data protection. And in case you've not already visited this, we also have a dedicated microsite specifically for all things data protection, which is our global data hub. And you can learn more about our practice and access compliance news and resources from the hub site. Includes things like news and updates with a bi-monthly mail shot if you register. Topical issues, where we take a look at regular issues that are raising concerns or issues or challenges, and where you can access the details of our forthcoming webinars and also the recordings of our archived webinars. The Global Data Hub site is also where you can access checklists and tools, and examples of other tools include our Global Data Protection Guide, where you can compare the national data protection laws of more than 60 countries. And we've also got our TW Cyber Response app, which is developed to help companies prepare, react and respond more quickly to a data breach should that occur. So just checking to see if we've got the results back. Okay, so in terms of the first question, have you reassessed your lawful grounds for processing personal data under GDPR? 50% have said yes, 37.5% have said ongoing, and 12.5%, sorry, I haven't got my glasses on, have said no. Moving on to the next question. So the next question was, has your business designated a data protection officer? So in relation to that question, we have 72%, just over 72% who have said yes, they have designated a data protection officer. Then we have 27.3% who have not yet got round to designating a designated DPO. It may be, of course, that they don't need to do so. And then thirdly, whether the business has implemented a data protection accountability management framework. And in relation to that question, 28.6% have said yes, 42.9% have that in progress, and 28.6% are yet to start. So it's quite clearly a pretty sort of organic process at the moment. And I think this is certainly what we're seeing with a lot of organisations where there was a high level and critical compliance points assessment prior to the GDPR, and there's now, particularly within this particular sector where I think there's still a lot of understanding around how it applies in practice, is coming out after the GDPR has come into force, where businesses are continually revisiting and reassessing their compliance. So it's quite clear data protection is not compliance is not a destination itself, it's an ongoing process. So I think we're nearly at the end of our time, and with that I just wanted to let you know that a recording of the webinar on the slides will shortly be available from the Global Data Hub microsite, and that you'll be able to access details of where you can also access details of the forthcoming events and webinars, and that's where you will also be promoting the details of part 2, which is going to be that slightly deeper dive into some more specific issues and scenarios and case studies relevant to life sciences and the processing of personal data. So look out for that, which will be probably in the next month or so, with the details of that next Part 2 webinar. So with that, it's just left for me to thank you for joining us today, and we hope that you can join us again soon. Goodbye.